3, 2, 1, start. In reply to the petitioner's argument to the effect that the appellate authority had mechanically rejected the appeal without any independent application of mind and without incorporating the reasons towards dismissal of the appeal, Mr. Mitra submits that if the order of the appellate authority is an order of affirmation, then it is not obligatory on the part of the appellate authority to pass a speaking order. Stop para. Mr. Mitra, in course of his argument, had drawn the notice of this court to the averments made in the affidavit in opposition to the effect that the sinister motive and deceitful conduct of the petitioner was explicit from the fact that the petitioner continued to keep installed at the premises in question, in which he was the recorded consumer, a defective stocked meter for about 16 months, and that thereby the petitioner prevented the board from collecting electric charges as per actual consumption and compelling the board to realize lesser charges on average estimated consumption of earlier months, and that such intention and action of the petitioner was to defraud to the board. Stop para. I have heard the learned advocates appearing for the respective parties, and I have considered the facts and circumstances of the case. Stop. It is well settled in service jurisprudence that authority concerned has to apply its mind upon receipt of reply to the SOCOS as to whether a further inquiry is called for, but in the instant case there had been no such application of mind on the part of the disciplinary authority, inasmuch as there is no semblance of any consideration of the petitioner's reply to the SOCOS notice, and the charge sheet issued is a replica of the SOCOS notice. Stop para. In my opinion, approval for issuing charge memo and approval of charge memo are distinct actions at distinct stages, and that the decision at both stages has to be taken by the disciplinary authority, but in the instant case, no such decision was taken prior to issuance of the charge sheet upon consideration of the reply of the petitioner to the impugned SOCOS notice, and such inaction on the part of the respondents tantamount to blatant violation of the principles of natural justice. Stop para. A perusal of the charge sheet reveals no incorporation of a charge to the effect that the petitioner had taken 16 months' time to replace his own meter, and no imputation in support thereto, and no accusation that such act tantamount to an act of misconduct in terms of the service regulations, and such infirmities render the charges to be absolutely vague and indefinite. Stop. It is well settled that an infirm charge sheet is violative of the principles of natural justice, and that it vitiates the entire decision-making process. Stop. From such sequence, it is explicit that the charge sheet suffers from patent legal infirmities. Stop para. In the reply to the charge sheet, the petitioner categorically answered the charge of low consumption as contained in clause A of the charge sheet, and the instances pertaining to the said charge as contained under clauses B, C, and D of the charge sheet, and upon consideration of such defense, the inquiry officer categorically observed as follows: :para. The other charge against Sri Jagannath Adhikari is that during the period from 01/01/01 to 05/02/02, average 40 units were charged, but again a supplementary bill was raised for last 6 months at the rate of 20 units per month after replacement of meter on 06/02/02. Stop. It evident that after replacement of meter, consumption comes to 263 units in between 08/04/02 to 15/07/02, 179 units in between 16/07/02 to 18/10/02, and 156 units in between 19/10/02 to 18/12/02. Stop para. The presenting officer failed to submit any documents or any analysis showing the consumption pattern of the same type of consumer in the above locality of Nandakumar gr.e/s, so that it can be proved that the consumption as claimed, that is 60 units within bracket 40 units plus 20 units bracket close, was very low. Stop. Hence the above charge has not been substantiated beyond reasonable doubt. Stop para. In the inquiry report, however, it had also been observed that the charged employee, being a station in charge, has taken 16 months' time to replace his own meter. Such type of irregularities in his own service connection are very much unbecoming being a station in charge, and that hence the above charge has been substantiated beyond any reasonable doubt. Stop para. Such observation of the inquiry officer is absolutely perverse, inasmuch as such finding does not stand fortified through any evidence on record. Stop. In the report itself, the said inquiry officer had observed that no prosecution witness was produced by the prosecution side. The records further reveal that the report of the inspection dated 18/01/2003, on the basis of which alleged charges were framed, was also not exhibited, and the blue card and the yellow card as marked as Exhibit A and Exhibit B were also not proved by producing any witness. And furthermore, the inquiry was abruptly concluded by conducting hearing only on two dates, that is on 21st/01/2004 and 23rd/03/2004, with direction towards filing of written arguments by the respective parties. Stop. An inquiry consisting merely of putting questions and inviting written arguments, without examination of any witness and without tendering any document in support of the charges, is unsustainable, and such infirmities in the decision making process warrants intervention of this court. Stop.